for the Legal Aid Bureau of Maryland, where she represented children in the foster care system, including representation in special education matters. For nearly 23 years, Selene represented parents in special education matters with a primary focus on least restrictive environment issues at the Maryland Coalition for Inclusive Education. Since September 2014, Selene has been the legal director for the Council of Parent Attorneys and Advocates, COPA, where she supports the work of the Amicus Committee as well as works on federal and local policy issues. In this position, she writes amicus briefs for appellate courts as well as the United States Supreme Court. Since May 2015, Selene maintains a private practice focusing on parent and student representation in special education matters, including LRE. Selene represents families at IEP meetings, state complaint proceedings, mediations, due process hearings, suspension expulsion proceedings, and federal court proceedings, including matters involving violations of the American with Disabilities Act and the Rehabilitation Act of 1973. She has extensive experience training families, teachers, school administrators, attorneys, and advocates on legal issues related to special education law, as well as disability discrimination issues. So without further ado, I'm going to go ahead and turn it over to Selene.
Oh, thank you, Kalani, very much. And thank you, Heidi, for inviting me today, this evening. I appreciate it. So we're going to talk about parental consent forms and what your rights are. I'm sharing my screen and I can see myself and the Down Syndrome Network of Montgomery County folks, but I'm looking in the waiting room when it comes up and can see that I know some people who are in the audience. So hello, good evening. We're going to go ahead and talk about consent forms, save the questions to the end. I only have 28 slides. I'm usually a voluminous PowerPoint person, but I'm hoping that we can talk through some of these things. I'm not giving legal advice. I'm just telling you what the law is and maybe some strategies for you to use with IEP teams. So the Individuals with Disabilities Act and consent. What does the federal law say? We know that when they changed the regulations and the statute in 2004, that they added this provision that parental consent must be fully informed. And so what does that mean? The way that I like to think about it is that fully informed means like when you go get some surgery and they give you a form to sign and you talk to your surgeon and you ask what are the risks, what are the benefits, what could happen, what's the best outcome, what's the worst outcome. The anesthesiologist comes to talk to you and tells you the same thing. What are the, what's the worst outcome? What's the best outcome? What do you hope to accomplish with the surgery? And so you have all of that information and then you can sign the consent form. So that's kind of how I look at this parental consent issue, is that you need to be able at IEP team meetings to ask as many questions as you want to ask. That's okay. And I understand because, as Kalani said, I have been doing this for over 30 years and I've been to thousands of IEP meetings. And I know there is an effort to get things done and completed and check the boxes. And everybody is happy and, done, move on to the next one. But it is your child's IEP team meeting. And you need to ask as many questions as you want to ask because you all have the right to participate in that IEP team meeting in a meaningful way. And so part of that meaningful participation is for parents to have as much information as you can get at an IEP meeting. And if the information at the IEP meeting is not enough for you to make a decision, then you can put your concerns in writing. You can ask for a separate meeting with someone on the team. If there's somebody from central office there that you need to talk to them, if there's a supervisor there, could I talk to you afterwards? you should not feel rushed about the consent at all, because the federal law does say that the consent that you give needs to be fully informed. And so to me, that means asking a lot of questions, and that's okay. That's okay to ask questions. I do a 12-week training course for the Council of Parent Attorneys and Advocates every year. And I think I'm on my 6th cohort, and I train new attorneys. And this is one thing that I tell them. It's okay to ask questions at an IEP team meeting. It's okay for you to do that. And so that's part of your role also as a parent. You know your child the very best compared to everybody else on that team. And so it's okay to sit and ask some questions. So when do you need to give consent? You need to give consent prior to an initial evaluation. So prior to your child being determined that they are in need of special education and an individualized education program, an IEP. You need to give consent prior to any kind of evaluations or assessments that the IEP team may ask you, may determine that they want to do. You have to give consent to that initial IEP, that initial provision of special education and related services. Many years ago, when school systems would ask parents to sign each and every IEP, parents, you didn't have to sign each and every IEP. The only IEP you ever have to sign is that very, very first one. So if you have a child that is coming out of infants and toddlers, that very first IEP, that's the only one you ever have to sign. You have to give consent prior to the school releasing documents that contain any kind of identifying information about your child. So those are the 4 areas that that you absolutely need to give consent for. So breaking those down and looking at prior to the initial evaluation. So I understand that there are other people on this on this Zoom call that may not have a child necessarily with a developmental disability. So it could be that you have a child that has been found through Child Find that does not have a developmental disability, but may have some other kind of disability that is not diagnosed by a physician, like with Down syndrome or autism. So that initial evaluate, so you go and you say, I believe that my child might need special education and related services, and the school system looks at those areas of need and decides that they're going to go ahead and do an evaluation. That's the initial evaluation. That's the first evaluation. It also could be that if you have a child that does have a developmental disability, you have a physician diagnosis, and you come to the school and you say, my child has Down syndrome, I need services. My child is coming out of infants and toddlers, and I know that that's like you're not asking the school to do any of that, but that initial evaluation under Part B, after 36 months, when a child moves into Part B of the IDEA, you do need to give consent for that initial evaluation, that very first evaluation. You need to give consent for any kind of reevaluation. So the law requires that every 3 years, an IEP team determine whether or not a child needs new assessments, new evaluations. That's reevaluation. Or if you have a child who all of a sudden has different behaviors in school that are having an impact on the child's ability to access education, you might need a new evaluation for that. All of that requires consent, and all of that requires that the consent be fully informed. So these are your times to ask questions. You have to give consent before you have the IEP implemented and prior to the school releasing any kind of documents. Now, looking at the third bullet, the prior to the provision of special education and related services, you do not necessarily have to consent to everything that's on that IEP. You can consent to pieces of it or portions of it and not consent to other pieces of it. So say that you have an IEP where you do not agree with the provision of services for speech and language. You want additional speech and language, but you agree with everything else. You agree with all of the academic goals. You agree with the placement. You can agree to all of that and still hold out your consent to you can still challenge the provision of speech and language. And that doesn't mean that the whole IEP is not implemented. That is a myth. Sometimes with initial evaluations and the initial provision of special education services, I have been in IEP team meetings where families are told, if you don't agree to this initial IEP, nothing is going to happen in the meantime. So that is not necessarily true. And the law does say, the federal regulations and the statute does say that there is nothing about consenting to one part that means that the IEP cannot be implemented. So the consent for an initial evaluation is a trigger for the initial evaluation process. The evaluation has to be conducted within 60 days of receiving that parental consent. This is what the federal law says. A state can change the time limit, and it can be longer than 60 days. And we're talking calendar days, so 60 calendar days. So sometimes teams may not want to start an initial evaluation or a reevaluation at the end of a school year because summer is coming. Evaluation times do not stop in the summer. Evaluation timelines have not stopped during COVID. So if you have a child right now who was in the middle of an initial evaluation process and your 60 days have run or are running, school system is still obligated to do evaluations. There has been no waiver of the timelines on their obligation to do child find through the initial evaluation or waiver of the timelines for reevaluations. So remember that, that there has been no waiver of those timelines. Clock is still ticking. The only way that school systems and states are ever absolved of these timelines is through congressional action. And Congress did not act on this at all. So the timelines still are ticking, all the timelines. In fact, during this COVID time, the one thing I learned is that the only time Congress has ever stopped the timelines was during Katrina, and that was only for the New Orleans school district. They said that they didn't have to comply with the timelines of IDEA because Katrina obliterated their school system. So that's the only time it has ever happened. So Maryland law requires 60 calendar days for the assessment or 90 days if a school receives a written referral. I got this from the Technical Assistance Bulletin, and honestly, I had never heard of this 90 days if a school receives a written referral. So I'm hoping that I don't, now I'm not recalling if it was in the Technical Assistance Bulletin and it explains it at all. So if you have questions about that, I can try to figure it out. Maybe somebody at Disability Rights Maryland might have the answer on this. But basically, we're looking at 60 calendar days in Maryland. So the consent for the initial provision of services. So if you consent to an initial evaluation that is not a consent for an IEP, That is not a consent for services. You have to give affirmative parental consent for special education to start for a child through an IEP. And then the responsibility for obtaining that parental consent lies on the school district. So there are some cases in the country where school systems have said parent wouldn't cooperate with coming to an IEP team. Parent was very difficult to deal with. So we didn't have an IEP. Parent, was, would not cooperate with reasonable requests from the IEP team. So we never could get parental consent. Courts have consistently said that that responsibility lies with the school. They have to try and get parental consent. Now, if you're the school, to me, what you would do is try to document all of that, all of the efforts that you made to try to get parental consent. But that obligation is on the school, just like the obligation for developing an annual IEP is also on the schools. School systems do try to paint families as being obstreperous and non-cooperative, and that's why they couldn't get an IEP. That is no fault of the family. That is always the responsibility of the school system to do that, to get the IEP and to get the parental consent. So if a parent, if you decline to consent to provide, if you decline initial evaluation, if you decline the IEP, you're not entitled to come back later and say, oh, I made a mistake, and I now am suing because my child didn't get a free appropriate public education. If you decline all of that, you're not entitled to use due process procedures later on to say that you did not get a free appropriate public education. If you decline to give that kind of consent at the initial evaluation or the initial IEP, the school system is not obligated to convene an IEP meeting or to develop an IEP. So all those cases that I talked about a second ago, those have to do with families who already had an IEP and communication with the school system broke down and they couldn't complete an IEP, they couldn't complete the evaluation process. But if if you decline that initial request for the initial evaluation and that initial IEP, you don't have a lot of recourse after that to claim that there has been a denial of FAPE. And, I understand why families would decline an initial IEP, an initial evaluation, because perhaps they're not the ones who came to a school with concerns about a child. They may be concerned about disproportionality. If they're a family of a Black or a brown child, that it is disproportionality that is driving this desire to label a child in need of special education services. I understand all of that. So those are all obviously considerations in in education. It is a reality that children of color are disproportionately labeled as needing special education in the categories of intellectual disability and emotional disturbance. And children of color are unnecessarily and disproportionately disciplined compared to white students, and students of color are disproportionately placed in segregated classrooms. So I understand all of that. However, the law is clear that if you decline it, regardless of whatever the reasons are, you can't come back and say that there was no FAPE. Now, having said all of that about federal law and what the federal law requires, in 2017, the Maryland General Assembly, due to a lot of work on a lot of advocates, passed a law that said that the IEP has to obtain the written consent of a parent if it proposes to do certain actions. And quite honestly, this came out of years of trying to change the burden of proof standard in Maryland that never really gained a lot of traction. Part of the idea of looking at this consent issue is that there are states in the country who have consent provisions. Massachusetts and Florida come to mind, so that you need explicit consent, that informed consent that we talked about in that very first slide, in order for a school system to be able to do certain actions. And so in Maryland, we started looking at this consent issue and a way to give families a little bit more leverage or power or control at IEP meetings, because I always look at IEP meetings as David and Goliath. You walk into an IEP team meeting and there are, 5, 7, 10 people, depending on your child who from the school district. And, you walk into an IEP meeting and everybody's already seated and they've already got their, mugs in front of them, right? And they've got all their papers spread out. In the before times, that's the way it was. And you would, walk into an IEP meeting either with yourself, your partner, maybe the tutor, maybe your advocate or lawyer, but it is a power differential there at IEP team meetings because they're already, they've developed a draft and they've already have met, before. You walk into that meeting, and so there is and always has been a power imbalance. And I am not saying that the power imbalance is purposeful, but it's there. And so this consent law tries to give back some of that or even out the playing field. It really is about leveling the playing field for families. And, I'm always cognizant of that because I did have a child who had an IEP during his school career. And that's not why I do this. I was already a lawyer doing this work when he was diagnosed. But I recall, even though I had already been doing this for a while, over 10 years, I recall what that felt like. And it does feel, there is nothing empowering about coming into an IEP team meeting when you're the parent. There just isn't, because there are so many emotions that are wrapped up in all of that, being the parent of a child who has a disability. So the Maryland consent law strives to sort of level the playing field. So the new law took effect on July 1, 2017, and it's been in effect for 3 years now. And the Maryland law does exceed the requirements of the federal law. States can always go beyond the federal law. They could just never go below it. So Maryland has chosen to do the consent law, and it does give you more options than what the federal law gives you. So good for Maryland. So the law does say that there are three. We know that in the federal law, the consent is only required for the initial evaluation, that initial IEP, and the reevaluation. And the IDEA allows a state to require parental consent for other services and activities, provided that there are effective procedures to ensure that a parent's refusal to consent doesn't result in a failure to provide a child with a free, appropriate public education. So Maryland requires the written consent of a parent if the team proposes to, number one, enroll the child in an alternative education program that does not issue or provide credits to a high school diploma. If the team wants to identify the child for the alternate alternative education assessment aligned with the state's alternative curriculum. So that's the alternative assessment. Or if the team wants to include restraint and or seclusion on the IEP to address the child's behavior, as described in the COMAR regulations. So those are the three things. Number one, to enroll a child in an alternative education program that doesn't give a path to a high school diploma. Number two, to place the child in the alternative assessment, statewide assessments. Or number three, to place restraint and seclusion on the IEP. If the parent doesn't give written consent, then the team has to send the parent a written notice of all of their consent rights no later than 5 business days after the last IEP team meeting. And they have to inform the family that you have the right to either consent or refuse. And if you do not provide the written consent or the written refusal within 15 business days, then the IEP team can go ahead and implement the proposed action. So those are 2 things that must happen. You have to get that written form when you leave the IEP team meeting, or they email it to you immediately afterwards, and you have 15 days. Typically, they write the date that it has to be returned on the form. So you know when it's got to be given back to them. And the reason why this is important is because if you don't say you decline to consent, then the action can go forward. So it used to be that the only way to stop anything from happening in an IEP team meeting, any kind of decision being implemented in these 3 areas, the alternative education program, the alt assessment, or the restraint and seclusion, was for you to file for a hearing in order to stop it, stop the action. But with this consent law, you have to give the written refusal to consent, and that stops the action from happening. So it gives you additional rights. It gives you important rights, and it gives you some power over, it empowers you to make a decision for your child, and know that if you say you don't want it to happen, then it won't happen, because they have to have your written consent in order for it to happen. So if you refuse to consent to one of the actions, obviously the IEP team can take you to hearing or mediation to say that they really want you to place the child on alternative education program, or what they call in the state of Maryland, the alternative learning outcomes, ALO curriculum, or place a child on the alt assessment for alternative assessment, or place restraint and seclusion on the IEP. They can take you to hearing. However, if they take you to hearing, they have the burden of proof of proving that their determination that a child be placed on the alternative learning outcomes or on the alternative assessment, or having restraint and seclusion placed on the IEP, that is their burden. So you don't have to prove or not prove anything. They have to prove to administrative law judge that that is the best thing for that child to receive a free appropriate public education. So the burden in lots of ways is on them to do it. If the Maryland Technical Assistance Bulletin has some question and answers, and so I thought that they were good. Many advocates, we were able to look at the draft of these technical assistance bulletins, and so we had some input into what kinds of questions would parents have, or what kinds of questions school teams would have. But if these 3 things are already on your IEP, do you have to get parental consent every year? Yes, you do. You have to get written consent every year, or every IEP team, meeting to continue on to do these things. So if your child was already on the alternative learning outcomes or already on the alternate assessment or had the restraint and seclusion on the IEP, you have to discuss these 3 things at the next IEP team meeting, and a parent has the option to decline to consent, even if it was already on the IEP. If one of these 3 things was not already on the IEP, you need to have a discussion of each of these 3 things. If there is any of those 3 things that they want to do, that they propose to do, and the parent can make a decision at the annual IEP team whether or not they're going to agree to these, one of those 3 things, whichever one it is, the ALO, the alternate assessment, or the restraint and seclusion. The Maryland Technical Assistance Bulletin does have a definition or an explanation of what an alternative education program is, or what an alternative education assessment is. I encourage you all to read it. I won't read it to you now, but it explains what it is. They're 2 separate things. Alternative learning outcomes does not necessarily mean that you're going to be placed on the alternate assessment. When the law was first passed on July 2017, lots of us had lots of IEP meetings where it was very confusing what they were asking families to sign. And it wasn't until November of 2017 that the MSDE, Maryland State Department of Education, came up with the Technical Assistance Bulletin, and it made it very clear that the ALO and the alternate assessment are not the same thing. They're 2 different discussions. They're 2 different written consent requirements. So you can be on the alternative learning outcomes without being placed on the alternate assessment, or you can take the alternate assessment without being placed on the alternate learning outcomes. Does the law prohibit restraint and seclusion in all instances without parental consent? So for years, many of us have advocated that restraint and seclusion doesn't belong on an IEP, doesn't belong on a behavior intervention plan. And the reason is that there is a state regulation that says that they can use restraint and seclusion if there is an emergency situation, if there's imminent serious, now it just ran out of my mind, imminent serious harm that is going to happen to the child or to someone else, then you can use restraint and seclusion. There is no federal standard, or there is no federal law on restraint and seclusion, so each state has had to come up with their own. So restraint and seclusion is only used in an emergency situation. And so it doesn't have to be on your IEP or on your behavior intervention plan, because it is a state law and it can always be used if there is an emergency, if somebody's going to suffer serious physical harm from behavior, either the student or someone else. So no, it does. There is still an avenue for restraint and seclusion in Maryland, even if a parent declines to have it placed on their IEP. So what if a parent does not provide written consent at the IEP team meeting? The IEP team can then not implement the proposed action. As I said, they have to get you the written consent form within 5 business days after the IEP team meeting. You have 15 business days in order to sign it in some fashion or another, either say, no, you do not consent, or yes, you do consent. Either way, you always have to sign it, because if you don't do anything and you don't send that form in, the action happens, it goes forward. So the only way that you can, stop it is to either say no, or if you agree with it, sign the consent. I encourage families to think about it. Say that you'll read it when you get home. Rarely, signing things right there when you're in the IEP team meeting, if you don't really fully understand it or you haven't gotten all your questions answered, it's just like, when you, and I'm not being glib, but when you, make a big purchase or make a big decision, you want to be able to think about it. So, I encourage people to, it's okay to think about it. You're going to get that form in 5 business days, which, if you have a meeting on a Monday, that means that you're not going to get it until the next Monday or Tuesday. So you have some time to think about it and then make a decision. Rather than signing it right there. So the notice has to, and I have a copy of the notice at the end. The written notice has to say that the parent has a right to either consent or refuse to consent, that the 15 business days is the trigger. If you don't do anything, the IEP team can implement the proposed action. If the parent is at the IEP team meeting, they can give you the written notice, which can be hand delivered to avoid delay. I've been with families where they give them the notice right there. Or they can send it to you not later than 5 business days after the IEP team meeting. In the world of COVID and Zoom IEP or Google Hangout IEP meetings, the forms are being emailed either that day or the day after or the 5 business days after. And so I know I'm a broken record, but the deadline for a response is those 15 business days after that. And if a parent provides written consent after that deadline, then the action can continue. They can go ahead and implement it. Yeah. And so if a parent provides written refusal after the deadline, then Maryland State Department of Education advises on the technical assistance bulletin that the action has to cease. So the child would remain where they were. The alternative learning outcomes would stop, or the restraint seclusion provision on the IEP would stop, or the alternative assessment would stop. If it's been after the deadline, best practice probably is to go ahead and convene another IEP team meeting. And this is just a business day. What business day means, it's a day when school is open, whether or not students are in attendance. So it doesn't include federal and state holidays. And then the technical assistance bulletin also gives you examples of, if an IEP team meeting is held on a Thursday, and an explanation of what 5 business days are. If the parent refuses to consent to an action and the IEP team disagrees, then they can go to hearing, go to mediation to resolve the matter. What happens if a parent consents to instruction based on Maryland's alternate academic achievement standards, but not the assessment, or vice versa? You have to obtain the consent. You don't need to consent to both. You can consent to one and not the other. And the team has to be cognizant of the fact that the two were not necessarily tied together. So parental consent is required anytime a student is identified as needing the alternate academic standards, or the ALO. And then here is a copy of the model parental consent form. Some parts of it are, you can see at the bottom, you have the right to either consent or refuse to consent. Here at the bottom on the parental consent deadline is typically where they write the date that you have to get it back in. It again tells you that if you don't submit it, return it, the IEP team can implement the proposed action. Up here at the top, they give you all the things that, everything that is supposed to be, that what they're asking you to consent to, and the fact that you absolutely need the written consent from the parent. And then the other part of the form is giving the explicit agreement to do this, to enroll the child in the ALO, to place the child on the alternate assessment, to place restraint or seclusion on the IEP, and then this written refusal, where you say you do not agree. And then this is, if you're going to not agree, then this is where you sign and get it in time before the deadline that is contained over here. So I have about 15 minutes for questions. I don't know if there are any questions about consent. Bottom line is that the Maryland consent law empowers families in those three areas. And so ask questions at IEP team meetings, ask questions about this model parental consent form. Make sure if you're given it that you get it back within that deadline, so that if you don't plan on consenting, that it doesn't happen. Now, the technical assistance bulletin does say that if you refuse after the deadline, they must cease doing it, but then you've got to go back to another IEP team. And also know that if you're already on the alternate assessment or on the ALO, that every year they have to reanalyze that, and you can withdraw your consent at that time. Okay.
Thank you, Selene. So there are several questions. One of the questions is, what would happen if the school does not inform a family of the parental consent?
Well, knowledge is power. So now, you know that there is this parental consent for those three areas. I think it could be a state complaint with Maryland State Department of Education that you were not informed about the parental consent provision. And you can file a state complaint, and they would get dinged for that, for not doing it for you.
Okay, thank you. Can restrained seclusion be used if there's potential destruction of property?
No, I mean, that's, that's the troubling thing about restraint and seclusion, is that, non-compliance or destruction of property leads into restraint and seclusion. And no, that is not what COMAR says. COMAR says serious imminent physical harm to the student or others. Mm-hmm. Destruction of property does not apply.
Thank you. Could you please clarify why a parent might want ALOs but not the alternative assessments, or vice versa? In either case, the child would be off the diploma track. Is that correct?
So the child would be off the diploma track. Yes. Either way. Yes. So the ALO might be because a student might be struggling, and a child and a family might want a child to remain in general education, and perhaps you want to see whether or not academic demands might be leading to some behaviors in class. That's always what a school team says. Sometimes families, if they have a child that they want to keep in general education and do not think that the child is going to be able to achieve a high school diploma, but really want to keep a child in a community school, may choose ALO. The alternate assessment, families may choose because the testing requirements are too rigorous, and they just don't want to do that for their child. But every family makes those kinds of decisions on an individualized basis. I feel that there can be that there is pressure from IEP teams and from school teams to place children on the ALO. Sometimes if you get an agreement that if you place a child on the alternative learning outcomes, the child can stay in their neighborhood school through the end of, 5th grade, through the end of 8th grade, through the end of, 12th grade. And sometimes families make that decision that that's really that's really what is important to them. Particularly as you get into high school where you have to earn credits. And if you're not going to be able to earn credits in 4 years, 6 years, 8 years, sometimes families then make the decision to move on to ALO.
Do you need parental consent in high school?
Yes, in these 3 instances, yes, you do.
So if you're switching programs, or so the same instances apply throughout the education process, K through 12. Right. Okay.
Right.
So once on the ALO track, is it all possible to get off that track?
Yes, because you make this decision every year. So if you're on the ALO for, say, like, I don't know, 8th grade, and you're thinking that a child might be able to earn high school credits in 9th grade, when the annual IEP team comes along and you make this decision again, you can say, I want to take my child off the ALO. And then the child, I refuse to consent to my child remaining on ALO. And so the child would have to come off. And obviously, if the school really thinks that that's what needs to be done, they can take you to mediation or take you to hearing in order to keep a child on ALO, but then they would have the burden of proof.
That was actually going to be my follow-up question, who the burden of proof would be on that in that instance. Is it possible to consent to ALOs without consenting to IQ testing?
Yes. Yes, I represent a lot of families who will not agree to IQ testing. That is, when I initially talked separating this parental consent issue in Maryland, when you're asked to consent to IQ testing, we ask a lot of questions on what they're going to use the testing for. One strategy is, if you have a child with Down syndrome, get a letter from the pediatrician, get a letter from the geneticist, get a letter from whomever that the child has trisomy 21, continues to have trisomy 21. You don't want IQ testing. You can hold off on IQ testing for a while. It gets harder as a child gets older to hold off. But it can, you don't necessarily need IQ testing for programming. You do need that IQ testing though to move a child to the alternate assessment and to that ALO. But they can use other kinds of evaluations if they have any other kind of education testing, things like that. Just looking, yeah. So you can hold off IQ testing for a while.
But they would still, so you're saying that if they're consenting to the ALO, they would need the IQ testing, or no?
So it's been my experience that teams are asking to move to ALO and they don't have IQ testing.
Okay.
They have other testing that they're using to justify it. But like I said, it is a decision that is individual to each family and what each family wants to do. If they get, if they get some sort of assurance that their neighborhood school remains the placement for the child, sometimes families just decide to move. move off of the general education curriculum. But that's not without a lot of, trying to do all kinds of other things before moving to the ALO.
So those are the questions that were in the chat room, and we still have about 10 minutes. So I just wanted to open up the floor to see if anyone had any additional questions. Okay. So if not, I wanted to thank, oh, hold on, sorry, that, we just got one side.
I talk fast.
That's okay. I've heard of times when IQ tests are named something else and parents are unaware that this was the test given. Is that legal? I've heard that too, actually.
What, that they didn't know that anytime a school psychologist says that they want cognitive testing, that's what that is.
Right. And I don't think they explain that. I think they just say cognitive tests and they don't really understand. I don't think parents really truly understand that it means that it's an IQ test. So,
yeah. I mean, all the more reason to, when you are presented with forms to sign to consent to that testing, like the cognitive testing, speech and language, where they check off those boxes, all the more reason to take that form and say you're going to think about it. And then that way you can ask people, what does cognitive testing mean? And then that's how you know that it's IQ testing.
And they're legally bound to tell you that it involves an IQ test. They should be telling you that if you ask for specifics of what, because I know I wasn't told.
I mean, that really is all about the informed consent. I know in my experience, families will agree to school testing and then be stunned when then teams move to change a diagnosis. They move to place a child on alternative learning outcomes, or they move to place a child in a learning for independence class, or a school community-based program. And it's all because families agreed to testing. I think that informed consent means exactly that. That's why I say it's okay to ask questions. So if they say, we need to do cognitive testing, what does that mean? I don't understand what that means. Somebody explain it to me. Is that IQ testing? That's why it's important to ask a lot of questions. And that's okay to ask questions at IEP meetings.
So sorry, you just mentioned that parents try other things before moving to ALO. What kind of things can parents try?
Well, before COVID, I would say look at what the delivery of instruction is like. Look at whether or not this child is receiving all their supplementary aids and services, whether or not the work is modified, or whether or not the child is getting all the accommodations, whether the child needs additional support, whether natural or through additional, a person to assist, all of those things pre-COVID, when we were in brick and mortar. And that's what I would say. Now, during COVID and distance learning, families have to make decisions based on this really unnatural thing that we're in right now, and the fact that Montgomery County doesn't seem to have a plan for returning to school anytime soon. So sometimes families make a decision during COVID to do ALO, knowing that because there is curriculum that can be given virtually, it's already done, is what I've been told. So they're not reinventing the wheel, particularly in a comprehensive elementary school or middle school. So it can be done and a child can start to access education ostensibly, but also understanding that the next IEP team meeting, you can always withdraw and refuse to consent again, and then it would stop and the child would go back to accessing general education curriculum.
Can you agree to alternative assessment and still be on the diploma track? So I guess it's.
I don't think so, no, I
Okay.
don't, yeah.
So you could be, sorry, I'm sorry. So you're saying that you cannot be, you have to be on the diploma track. You cannot have alternative assessments on the diploma track. Is that?
Right, because yeah, yes, if you're on the alternative assessment, then you're not going to get a high school diploma because it is different curriculum and different criteria for testing standards. So no, you can't, you're removed.
Okay. When the 15 days to return the consent form is all gone and the parent does not want to consent to special education, can they later change their minds, or do they have to start the process of having an IEP meeting again and having including the evaluations?
So the question is, so the 15 business days only applies to these three things: the alternative education program, the alternate assessment, or restraint and seclusion. That's the only thing that the 15 business days applies to.
Right.
If,
Sorry, go ahead.
If you refuse to consent to the provision of special education services, just in general, and then later on you decide you want it, yes, probably you have to restart all of the evaluations, and you cannot go back and say, the first time that you asked me, I said no, you should have made, you should have tried to convince me, or my child never got FAPE during that time. Yeah, you would have to start all over again.
But you are given, as you mentioned before, every year you're consenting. So yearly you're consenting to each of the items that you mentioned, so that you have that opportunity every year in your annual IEP review. Is that correct?
Only for these three things.
Right.
In Maryland. Right.
Okay. Okay. I think that is it. Anyone else have any additional questions? We have about a minute or so. So just want to make sure that we get them all in. All right. Well, thank you so much, Selene. As I mentioned before, this is the first of our parent workshops, so we look forward to hopefully seeing you all again in a future workshop. And Selene's information is included in the PowerPoints, and it will be on the DSNMC's website, which is dsnmc.org, shortly, hopefully soon.
Okay.
Okay, thank you again.
All right. Stay safe.
Thanks.